Hello and welcome to my channel Patel Legal Updates. Today I am going to teach you Order 6 of CPC 1908, which generally deals with pleading. Rule number 1, pleading. Pleading shall mean plaint or written statement. Rule number 2, pleading to state material facts and not evidence. 1. Every pleading shall contain only a statement is a concise form of the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved. 2. Every pleading shall, when necessary, be divided into paragraphs numbered consecutively, each allegation being, so far as is convenient, contained in a separate paragraph. 3. Dates, sums, and numbers shall be expressed in a pleading in forms as well as in words. Rule number 3. Forms of pleading. The forms in Appendix A, when applicable and where they are not applicable, forms of the like character as nearly as may be shall be used for all pleadings. 3a. Forms of pleadings in commercial courts. In a commercial dispute where forms of pleadings have been prescribed under the High Court rules or practice directions made for the purposes of such commercial disputes, pleadings shall be in such forms. Rule number 4. Particulars to be given where necessary. In all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the forms aforesaid, particulars with dates and items if necessary shall be stated in the pleading. 5. Further and better statement or particulars omitted by the Code of Civil Procedure Amendment Act 1999 with effect from 1st of July 2002. Rule number 6. Conditions precedent. Any conditions precedent the performance or occurrence of which is intended to be contested shall be distinctly specified in his pleading by the plaintiff or defendant as the case may be, and subject thereto an averment of the performance or occurrence of all conditions precedent necessary for the case of the plaintiff or defendant shall be implied in his pleading. Rule number 7. Departure. No pleading shall, except by way of amendment, raise any new ground of claim or contain any allegation of fact inconsistent with the previous pleading of the party pleading the same. Rule number 8. Denial of contract. Where a contract is alleged in any pleading, a bare denial of the same by the opposite party shall be construed only as a denial in fact of the express contract alleged of the matters of fact from which the same may be implied, and not as a denial of the legality or sufficiency in law of such contract. Rule number 9, which deals with effect of document to be stated. Wherever the contents of any document material, it shall be sufficient in any pleading to state the effect thereof as briefly as possible, without setting out the whole or any part thereof, unless the precise words of the document or any part thereof are material. Rule number 10 deals with malice, knowledge, etc. Wherever it is material to allege malice, fraudulent intention, knowledge, or other conditions of the mind of any person, it shall be sufficient to allege the same as a fact without setting out the circumstances from which the same is to be inferred. Rule number 11 deals with notice. Wherever it is material to allege notice to any person of any fact, matter, or thing, it shall be sufficient to allege such notice as a fact, unless the form or the precise terms of such notice or the circumstances from which such notice is to be inferred are material. Rule number 12 deals with implied contract or relation. Whenever any contract or any relation between any person is to be implied from a series of letters or conversation or otherwise from a number of circumstances, it shall be sufficient to allege such contract or relation as a fact and to refer generally to such letters, conversation, or circumstances without setting them out in detail, and if in such case the person so pleading desires to rely in the alternative upon more contracts or relations than one as to be implied from such circumstances, he may state the same in the alternative. Rule number 13 deals with presumptions of law. Neither party need in any pleading allege any matter of fact which the law presumes in his favor, as to which the burden of proof lies upon the other side unless the same has first been specifically denied. Example, consideration for a bill of exchange where the plaintiff sues only on the bill and not for the consideration as a substantive ground of claim. Rule number 14 deals with pleading to be signed. Every pleading shall be signed by the party and his pleader, if any, provided that where a party pleading is by reason of absence or for other good cause unable to sign the pleading, it may be signed by any person duly authorized by him to sign the same or to sue or defended on his behalf. 14a deals with address for service of notice. 1. Every pleading when filed by a party shall be accompanied by a statement in a prescribed form signed as provided in rule number 14 regarding the address of the party. 2. Such address may from time to time be changed by lodging in court a form duly filed up and stating the new address of the party and accompanied by a verified petition. 3. The address furnished in the statement made under sub rule 1 shall be called the registered address of the party and shall until duly changed as aforesaid be deemed to be address of the party for the purpose of service of all processes in the suit or in any appeal from any decree or order therein made, and for the purpose of execution, and shall hold good subject aforesaid for a period of 2 years after the final determination of the cause or matter. 4. Service of any process may be effected upon a party at his registered address in all respects as though such party resided threat. 5. Where the registered address of a party is discovered by the court to be incomplete, false, or fictitious, the court may either on its own motion or on the application of any party order. A. In the case where such registered address was furnished by a plaintiff, stay of the suit, or B. In the case where such registered address was furnished by a defendant, his defense be struck out and he be placed in the same position if he had not put up any defense. Where a suit instead or a defense is struck out under sub rule 5, the plaintiff, or as the case may be, the defendant, may, after furnishing his true address, apply to the court for an order to set aside the order of stay, or as the case may be, the order striking out the defense. 7. The court, if satisfied that the party was prevented by any sufficient cause from filing the true address at the proper time, shall be set aside the order of stay or order of striking out the defense on such terms as to cost or otherwise as it thinks fit, and shall appoint a day for proceedings with the suit or defense as the case may be. 8. Nothing in this rule shall prevent the court from directing the service of a process at any other address if for any reason it thinks fit to do so. Rule number 15 generally deals with verification of pleadings. 1. Save as otherwise is provided by any law for the time being enforced, every pleading shall be verified at the foot by the party or by one of the parties pleading or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case. 2. The person verifying shall specify by reference to the numbered paragraphs of the pleading what he verifies of his own knowledge and what he verifies upon information received and believed to be true. 3. The verification shall be signed by the person making it and shall state the date on which the place at which it was signed. 4. The person verifying the pleading shall also furnish an affidavit in support of his pleading. 15a. Verification of a pleading in a commercial dispute. 1. Notwithstanding anything contained in rule number 15, every pleading in a commercial dispute shall be verified by an affidavit in a manner and form prescribed in the appendix to this schedule. Second, an affidavit under sub-rule 1 above shall be signed by the party or by one of the parties to the proceedings or by any other person on behalf of such party or parties who is proved to the satisfaction of the court to be acquainted with the facts of the case and who is duly authorized by such party or parties. 3. Where a pleading is amended, the amendments must be verified in the form and manner referred to in sub-rule 1 unless the court orders otherwise. 4. Where a pleading is not verified in a manner provided under sub-rule 1, the party shall not be permitted to rely on such pleading as evidence or any of the matters set out therein. 5. The court may strike out a pleading which is not verified by a statement of truth, namely the affidavit set out in the appendix to the schedule. Rule number 16 deals with striking out pleading. The court may at any stage of the proceedings order to be struck out or amendment any matter in any pleading. A. Which may unnecessary, scandalous, frivolous or vexatious of. B. Which may tend to prejudice, embarrass or delay the fair trial of the suit. Or C. Which is otherwise an abuse of the process of the court. Rule number 17 deals with amendment of pleadings. The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such a manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of the diligence the party could not have raised the matter before the commencement of trial. Rule number 18 generally deals with failure to amend after order. If a party who has obtained an order for leave to amend does not amend accordingly within the time limited for that purpose by the order, or if no time is thereby limited, then within 14 days from the date of the order he shall not be permitted to amend after the expiration of such limited time as aforesaid, or of such 14 days as the case may be, unless the time is extended by the court. Thank you.